when you bring in international investors, you are actually an IRS agent. I keep saying that kind of in tongue in cheek, but it's true. You actually become an IRS agent because you have a withholding requirement on behalf of the IRS to withhold 30% of any profits that the international investor should be receiving. Welcome back to Real Estate Syndicator Live, episode 11. Can't believe we've been doing this for almost 3 months now. So super appreciative of you guys being here. A couple quick announcements. Next week, next Wednesday, same time, same bat channel, we're going to have the great Ken McElroy in town. He's been gracious enough to give us a little bit of his time. And for those of you who don't know Ken, he's probably one of the top syndicators out there, right? So he's got over, I think he's up to like 10 to 12,000 units, $1 billion in assets under management. So he's nice enough to come join us and part some of his knowledge and wisdom for us. So looking forward to that next week. And then tomorrow, which is kind of a unique thing, but tomorrow, Thursday, Bethany is going to be hosting a new series for us called Conscious Wealth Building Through Syndication. And we've got a great panel, our inaugural panel with Kathy Fedke, Ashley Wilson, and Maureen Miles. So that's going to be an awesome panel. And we're kind of just trying out the new format as well. So you'll probably get an email if you haven't already about that tomorrow. But Bethany, maybe you can put the link to that in the chat if people want to. I think it's just bethanylaflamme.com, but if you want to put that in there, that would be great. And without further ado then, today's topic, I'm just going to riff for a little bit, is international investing. We've got a lot of clients and just actually even non-clients who've been reaching out about this issue of international investing, and figured why not go through some of the common mistakes, or I don't say mistakes, but the things that people don't think about when they're doing when they have international investors in their deal. And so let's go through some of those common mistakes. The first one that I wanted to address, which is probably the most important one, which is why I decided to post that on the social media and the email that you guys saw today, assuming you saw it, and that is not realizing that when you bring in international investors, you are actually an IRS agent. I keep saying that kind of in tongue in cheek, but it's true. You actually become an IRS agent because you have a withholding requirement on behalf of the IRS to withhold 30% of any profits that the international investor should be receiving. Now, it's important to recognize that it's a withholding. It's not necessarily a tax. A lot of people say, oh, you get taxed at 30%. No, you get to withhold 30% of the profits. So the idea is that that'll force the international investor to actually file a tax return and report that income in the United States, right? Because otherwise, there's no incentive for that person to do so. And so by withholding it, if the tax ends up being lower, let's say the tax ends up being 12% or 13%, great. They'll file a tax return and then they'll get a refund, just like many W-2 employees get a refund after they have the withholdings. So it's not a tax, it's a withholding. And again, this is something you want to be talking with your CPA, but my understanding is the same exact sort of deductions and depreciation and all that stuff will come into play. So if you've got bonus depreciation and the profit ends up being zero on paper, then there's not going to be a withholding tax or a withholding on that $0. But again, just check with your CPA, but you do have that obligation to withhold 30% and file the appropriate paperwork with the IRS. You've got to file the tax forms with the IRS, send the funds into, I believe, the Treasury Department, so that you have you have agreed with your responsibilities. The issue is if you don't do that, and the international investor fails to file a tax return and doesn't pay whatever tax the government believes they owe it, they could come after you for that unpaid tax. So it's really, really important for you to at least be aware of that, so you can have that discussion with your CPA. So that's probably the most important one, or one of the most important things, and a common mistake that people just don't realize that that's an obligation. The second thing is not checking with the securities laws in the country where your investor is located. The US doesn't really care, to be honest with you. If the international investor is not a US person, is not a US citizen, is not physically located in the United States, and you're not marketing, obviously you're not going to be marketing that person in the United States, so you're just marketing them out overseas, then honestly, the SEC doesn't care. I always joke that, I mean, theoretically, you could go rip off an investor in in another country. And again, the SEC is here to protect US investors and its people. It's not really caring about international investors. However, the country where the international investor is absolutely cares what, whether you're defrauding them or doing anything like that. So you want to make sure that you're at least checking in with somebody in that country that has some understanding of securities laws. Now, to be honest with you, or to be fair, the vast majority of countries don't really have a very robust securities law like we do. Canada is probably an exception in some of the European countries, but as you guys know or may not know, I used to live in the country of Belize. And I'll tell you what, there's not much securities laws going on down there. But if you're raising money, from somebody in Canada, for example, just make sure you're checking with a Canadian securities attorney, make sure you're not violating, especially if you're traveling up there and making presentations up there. Same with Mexico. Those are probably the two countries where you're most likely to actually physically go travel. But we do have people who have clients in Asia, in the UAE, and they physically travel and actually go to those countries and make a presentation or meet with people in that country. And you just want to make sure that you're not violating any of those securities laws. But from the US perspective, the SEC is in the business of helping and protecting US citizens and US persons. So as long as they're outside of the United States and not one of those two, you should be fine there too. The third mistake, and this primarily happens with Canadian investors, but the mistake is not checking to make sure that the LLC structure, which is what most syndicators use, is even recognized in that particular country. Right, and Canada is just a perfect example because number one, it's obviously the country that's the closest to us, and where most likely the most international investors will come from is from the country of Canada. And Canadians don't, or the country of Canada doesn't recognize LLCs, limited liability companies. And so what happens at that level is that they just default to a corporation on their end. So they get double taxed. If you have a Canadian investor come in and own, your syndication in an LLC, their government, their taxing authority is going to treat that as a corporation, and they're going to get double taxed, which means your Canadian investor is not going to be very happy with you once they realize that whatever returns you've given them have been diluted thanks to the tax man. So again, it's just something you have to be aware of. There's really two things I would do there. Number one, again, kind of a repetitive thing here, but make sure that your Canadian investor has a Canadian CPA that they're consulting with to make sure that the way that you're structuring or they're structuring is the most tax efficient for them. And then on our end, the way we typically solve that problem is through what we call a limited liability, limited partnership, or sometimes just a limited partnership. But we want to make sure that our syndication is not an LLC. If we have a lot of Canadians, and we want to make sure that our syndication is actually ideally a limited liability, limited partnership, an LLP, or I have heard from some Canadian CPAs that an LP is sufficient. But again, those are questions that we have to ask the Canadian CPAs so that we're comfortable that our investors aren't going to get into any trouble from their taxing authorities. Another big deal is, or a common mistake is, and I've referenced it a few times now in this little spiel, is that not working with the appropriate CPAs. I think on our end at the US level, we want to make sure we're working with a CPA who is familiar or really is an expert in cross-border transactions so that they have experience in not just dealing with US investors, but there are CPAs who specialize in dealing with cross-border. So whether it's Canada or Mexico or just the United States, they're the ones that are going to be familiar with your withholding requirements. They're going to be familiar with any tax treaties that may exist between the two countries. So having a CPA that you're working with that is familiar with cross-border transactions, I think that is huge. And then on the converse side, making sure that your investor is working with a CPA in their own country, or at least you're asking them. I guess what I would do is actually specifically say, look, I don't know anything about Canadian taxing authority. I don't know anything about Chinese taxing authority. So please make sure that you're passing the structure through them, because we're not here to tell you one way or another. So make sure that you've got your own tax professional involved in that. Now, obviously, all of that is going to be in our disclosure documents that we're preparing. But again, you just want to be, even if you're technically correct and it's in the PPM and the offering documents, the last thing you want to have is an unhappy investor because they weren't even aware of this. And so at the very least, I would say it's your, maybe not legal obligation, but maybe just good practice for you to be advising your investors that they should be checking with their tax professionals, so we're avoiding any of these cross-border taxes, which is the main issue. And then the last issue, which you've got to be careful about, is just the anti-money laundering statutes. We usually don't think about those in our syndications, but we do have an obligation to make sure that when we're receiving monies from whatever country that, you're not taking money that's, terrorist money or, black diamond money or whatever it is. So you want to make sure that you're complying with the anti-money laundering statutes. And also we have our KYC, or your customer rules. So you really want to be doing a little bit more due diligence in who this investor is, how did you meet them, and doing a little bit of due diligence to make sure that you're not taking money from someone who's basically just trying to launder, dirty money and get it clean through your syndication. That's probably the last thing you want to do. One other thing, which I actually just thought of as we were talking about the anti-money laundering thing, this is not so much a common mistake, but I would maybe chalk this up as a recommendation as best practice. Anytime you receive a wire from another country, from an international investor, there's always a possibility that something happens here in the United States in terms of a withholding, or something just doesn't seem right, and the government comes in and puts a hold on that money. You can't imagine the horror stories that I've heard where people are, especially when it's a large amount of money, like a $5 million wire. If your bank isn't aware of it or isn't ready for it, they suddenly see a $5 million wire coming from somewhere. I've heard nightmare stories where there's a governmental agency that's in charge of financial crimes, and they come in and they literally put a hold on that money while they do a due diligence on where that money came from. And that can take a week, 2 weeks, 3 weeks, or a month. And the specific story I remember is somebody had the money wired in on a Friday, and they had to close on Monday, and they had a hold on it, and they had to go up numerous levels of management and the manager and the manager and the VP of the bank or whatever to get that money released. So best practice is, if you've got really honestly, if you've got any amount of money, I think it's a good practice, but certainly if you've got a large amount of money that's coming in from overseas, call your banker, meet with your banker, just let them know the money's coming, ask them what it is that they need in order to make sure that this is a smooth transition. Do they need maybe a passport or just whatever information that they will need to make sure that that transaction is smooth? Because again, the last thing you want to do is receive a big chunk of dough from overseas investor and have that money stranded in either the banking system, because your bank's put a hold on it, or even worse, the federal government coming in with their, and I forget the name of it. It's sort of the financial crimes division. I'm sure somebody in the chat can let us know. But there's definitely a governmental agency that has the power to come in if they don't like what they see and put freeze your account basically, or that money, until they do their due diligence. So I think that's kind of my 4 or 5 or 6. I lost track of how many issues really that you want to think about when doing international investing, but I know it's been a big topic, and so I want to make sure that we answer your questions specific to that topic, and if you guys have specific examples or specific things you guys are concerned about. So Bethany, you want to let some people in here who have some questions here.
Sorry, unmute myself here. Well, so the first question is from Kim. Hi, Kim of Quattro Capital.
Kim?
Go ahead. I'm going to let you ask your question, Kim, because we always want to hear from you.
You're hilarious. I was just curious, in the establishing of the entities that would be compliant with whichever country, do you guys at PLG handle the international clients? Can you help facilitate that entity work?
So the answer to that is no. We can facilitate it in that we can make introductions to service providers who can create. I mean, I actually just saw, it's interesting, I just saw somebody mention Stuart Patton, who I've actually worked with. So he's, I think he's actually down in Belize. I don't know if Stuart's even here. But so yeah, so if you've got a deal down in Belize, Stuart would be somebody perfect to go set that up. I don't know if he sets up other LLCs or other companies in Central America, but I recall having a deal with some Asian investors, and they wanted to set up a Hong Kong entity. And so we ended up finding a provider who would set up a Hong Kong. We're not in the business. I wouldn't know the first thing about setting up a Hong Kong company, but we can certainly facilitate that for our clients.
But I'm talking more specifically the US side.
Yeah, so we would facilitate the structure for sure. That's one of the things we would absolutely do. Yeah, so we want to find out, on the Canadian side, it really depends on how many. If we can find out ahead of time that you have Canadian investors coming, then that's better, because then we'll just create the limited partnership. We'll just connect with the CPA over there and say, hey, is that good enough? If we created an LP instead of an LLC, will that work? Great. I've got some conflicting, and this is why you always want to check with your CPA. You want to create your syndicate here. You want to create, mute all those here, sorry. You want to create, what was I saying, sorry. You want to, oh, I lost my train of thought there. Bethany, where was I?
About creating the US entities. We want to make sure that we're not giving the legal or tax advice, and depending on which country they're coming from, you want to make sure that they're creating whatever LLC that their tax advisor or their legal advisor advises without.
Oh, yeah, no, I know. Sorry. Yes. Thank you for that. I'm getting some conflicting comments from different CPAs in Canada. So apparently my joke about US CPAs, and forgive me if you got CPAs here, but my joke about CPAs, which can also apply to attorneys. But if you ask 3 CPAs the same question, you get 5 different answers. Similarly, I guess in Canada, because we asked, I've been speaking with some Canadian investors, CPAs, and they're telling me that one way around this is for the individual Canadian investor to first create a limited liability company, or I'm sorry, a limited liability partnership, and then invest into your LLC through that LLP. But then I've also had other CPAs say that no, that doesn't cut it. And so again, that's why it's just critical to make sure you're talking to tax professionals in the particular state where the country is, and basically follow whatever they're telling you if you're not setting it up yourself. But we'll help you structure that for sure.
All right.
Thanks, Kim.
Am I unmuted? I am unmuted. Okay, perfect. Okay, so Ludi, Levi, did I say that right, Ludi? I know you have a question. That's a good question.
Yeah, correct.
Yes, great. Go ahead.
So Mauricio, thank you so much for the great value that that you bring every week. Highly appreciate that. Thank you first.
No, thank you. Thanks for all of you.
Sure. And my question is about the accredited investors 506C. So when a syndication in the state is formed and they're asking for 506C investors, is the definition is the same for international investors from Canada or elsewhere in the world? I mean, the 200K and all those numbers. Or if I'm Canadian, or let's say have another passport, I can go into that 506C. Since again, I'm not American, so I will not probably follow, in these, if I have, let's say, an LP company, limited partnership company.
Yeah, so great question. The question essentially is how do you verify accredited investor status for international investors? And the answer to it is it's the exact same verification. So remember, your obligation under a 506C is you're required to take reasonable steps to verify that they are accredited. And we don't usually talk too much about this, but there's really actually 2 ways you can do that. One is the safe harbor, which most of the time we rely on. So, if it's income, you're going to look for W-2 for taxes, CPA verification letter, any of that stuff, that's kind of the safe harbor. But you can actually do any steps that you can argue that you reasonably took in order to confirm that they are accredited. You can rely on that. And so for income purposes, it's still $200,000 a year, or $300,000 if you're going jointly, and you just have to do the conversion. So that's the tricky part, right? So I mean, it depends on what the currency exchange rate is at the time of the sale. But at the time of the sale, you're going to have to convert in whatever the currency conversion is for that. And if they're relying on net worth and stuff, then obviously you're going to do the same thing. You're going to be requesting whatever assets they are. You're going to look at their liabilities. It might be a little bit harder to get liabilities since you're not going to be getting sort of a credit report that they have. So I think, to me, the easiest way, if it's ever a close call, I would rely on the Reg S, because that's the other way to do it. So 506C is what requires you to take reasonable steps to verify. Reg S doesn't care. So what I would probably recommend, if it's even close, or honestly, I've even recommended, if you've got a couple of non-accredited investors who are overseas, bring those investors in under the Regulation S exemption, because again, as long as you don't market the deal, that particular thing, to those investors here, they're outside of the United States, they're not US persons, they're not US citizens, then, the US isn't going to care that they're not accredited. Again, making sure we're not violating the rules over there. So to me, that's the easiest way to do it. But going back to my initial thing about verification, I would definitely be making sure that I'm using a third-party verification company, because that using a third-party verification company essentially shifts all that liability off of your plate onto the plate of the third-party verification. Let them handle how they're going to figure out whether that international investor is accredited, and let them give you that letter, which is usually from an attorney, that says, hey, we've done our due diligence, we've taken reasonable steps to verify this person's accredited, who lives in wherever, and I'm telling you this person's accredited. You can then rely on that letter. So I recommend that for all of them. I don't think the risk is worth saving the $50 or $60. So I would always use a third-party verification company, but even more so, I would do it when you have international investors that you're trying to verify that they're accredited, or just bring them in under Reg S.
Awesome, thank you so much. That answers my question. I thought that for international investors, they're exempt from that requirement to be accredited, since they're not American, and the SEC law is protecting Americans, not international investors.
That's right. So bringing them into Reg S, which is what you're talking about, that's exactly right. So if you bring them in under the Reg S exemption, then we don't have to worry about that stuff, because Reg S doesn't have a requirement that they have to be accredited, or you can. The only requirements from Reg S is just making sure that they're they're not US persons, not US citizens, and you're not marketing that particular offering here in the United States, which you wouldn't be.
Thank you very much.
Of course. Good seeing you, Ludi.
Very good. We've got a few people with their hands up, but we did have another question prior to that from Brady Hoffpower. Brady, do you want to unmute and ask your question?
Yeah, sure. Thanks, Bethany. Mauricio, thanks for sharing all this. Super interesting and informative. Really appreciate it. The question I had is, if there's someone that's not a U.S. citizen, but they're living in the States currently, and they provide you with a Social Security number, they say they're paying taxes, how much of what you outlined here also applies to that type of investor?
So if they're physically in the United States, we can cross off our list the Reg S option, because if they're physically in the United States at the point of sale, then they're not going to be eligible for the Reg S exemption. So I'll cross that out of play. And the same thing, by the way, applies if they create a US LLC. That's another issue that, it's one or the other. But I have international investors who want to either have a US LLC or want to create a US LLC. That makes them now a US person. So that'll blow the Reg S. But no, I mean, I think that alleviates most of the issues. I mean, if you go through our list, I'm not worried about, presumably they have presumably they're investing through some kind of are they investing through an entity in the US? I guess maybe they don't have to be. Are they residing in the US or just visiting?
So I know investors that have, both scenarios, have an LLC in the US that they invest through, or they are investing as a individual. But also have a social, and they at least say they pay taxes.
Yeah, I mean, if they have a US LLC, then they're a US person. So it doesn't matter, what country they're from. From your perspective, you're going to issue a K-1 to the LLC, right, and then the LLC is going to, distribute monies that way. So it does help a lot when they have a US bank account, and whether they pay their taxes here. There would still be the withholding requirement, I believe. No, actually, that's not true, because you're going to be sending it to a US bank account. So as long as you're sending it to the US bank account, it's going to be the issue of when that gets withdrawn from the US bank account. So that does make a big difference if they have an LLC, but even if they're physically in the United States, that's going to alleviate it's going to alleviate the anti-money laundering, because presumably, well, I guess it depends on where that money's coming in from. But on the anti-money laundering, by the way, most of the time, you're going through a huge corresponding bank, which is going to be doing all their KYCs for you, and they're going to make sure that there's no anti-money laundering issues, which is why there's that potential of getting withheld. But it gets a little tricky when people, and I've had some clients who are wanting to accept, cryptocurrency, for example, in for those things. Well, now, yeah, you can definitely accept crypto, but then you have the issue of, well, who's making sure that, where that crypto is coming from? How do you know, who the investor is? How are you going to give that investor K-1? So there's other issues that pop up there. But if you typically, if you're going through a US bank, like most of the corresponding banks are Bank of America, Wells Fargo, Chase, whatever, they're going to do their thing. And then there's a list that you want to make sure we're checking against. I don't know exactly the name of the list. It's kind of like an anti-money laundering list of people who are on the not the FBI's most wanted list, but it's kind of like a most wanted list. So you want to make sure that those individuals aren't on that list.
Right. Okay. Thank you so much.
Of course.
Mauricio, about the Reg S exemption, this is also like will take effect even, let's say the international investor, he's forming a limited partnership that he will invest in that syndication. Will be able still to exempt him with the Reg S, or once the entity is formed that he's investing through it, it will not be, he will not be able to do that.
No, you wouldn't be. Once the minute they invest through assuming it's a US LP, then your investor is a US person. The definition of a US person is not just an individual, but an entity. So at that point, it's considered a US person. So that's why sometimes it's like one or the other. Right? So on the one hand, you solve your issues of the withholding and all that stuff because they've set up a US LLC, but then you blow the opportunity to do a Reg S because it's now you're dealing with a which is great because now you're dealing with a US person. You're just going to issue a K1. You're going to distribute the money to their bank account and then let them figure out how they're going to repatriate the fund. Maybe they don't want to. Maybe they're going to keep the funds here in the United States. Who knows? That's probably what's going to happen anyway. But that will negate all the stuff we talked about if they set up a US entity.
Awesome. Thanks.
All right. Thanks, Liddy.
Great. Well, we have a bunch of people with their hands up. I don't
Yeah,
you can go in order. You can go in order. AJ?
Yeah. Hey, Mauricio, how are you?
Good, AJ. How you doing, my friend?
Hey, doing good, my friend.
See you.
Yeah, I have been. I enjoy your these webinars every week, man. It's really good.
Well,
So one quick question I have. So we have a scenario where there is a U.S. citizen, but he does not live in United States anymore. He lives overseas. So his address, physical address is overseas, but he has a US bank and he has social security number and everything. So do you see any issue in that kind of scenario?
And he's a US citizen or a US resident?
Yeah, he's a US citizen, but he does not live in US anymore.
Yeah. Well, remember, we have the privilege of living in, I think it used to be 2 other countries, but I think we're maybe the last remaining country that will actually tax you on worldwide income. So, first of all, the Reg S doesn't apply because they're a US person. Just because they don't live in the United States or aren't physically in the United States doesn't help you. So they're a US person, so they're going to have to comply with the same 506B, 506C regs that we're bringing them under. Obviously, there's no withholding requirement because they already have an obligation to file tax returns, or if they have an exemption because they're living overseas for more than 11 months, or the other test, I think it's I forget the name of these tests, but one's 11 months out of the year they're living outside, and the other one is I forget the name of it, but they're going to have an obligation to do something from an IRS perspective. So yeah, none of those issues really going to come into play if they're a US person that just happens to be living offshore. So the answer to that is no different from us.
So in order for them to file taxes, or for us, if let's say we have their overseas address, it really does not matter, right?
In terms of what you have their overseas address, it doesn't matter for what?
So let's say if because in our file, remember that when we file the Blue Sky filing and on all those things, so Blue Sky filing is for a specific state.
Yeah.
But since they don't have they don't live here, so how the Blue Sky filing will work in this case?
They wouldn't. Yeah, you would be on that particular investor. You would be exempt. There wouldn't be a Blue Sky filing because the sale of the security happened in a different country. So there wouldn't be a Blue Sky filing requirement for that particular issue.
Okay. Thank you, Mauricio. Thanks a lot.
AJ.
Yeah, same here.
AJ. So Sindel, I actually just saw your Facebook message right before this started. And Mauricio, this is the one I was telling you about. I was like, oh, I guess we'll have to give her the link because I saw it right before this. So great, you're here. You can ask your question.
Sindel, how are you?
Hi, how are you?
Doing great.
Thank you. Great. My call got a lot of good information. So I used to be investment banker back in Brazil, and I have some investors there that I would like to, offer the multifamily opportunity for them. And because they said we have to follow the SEC rules on the country about being accredited or not, it's another word, it's like professional and like whatever is another word. And so I need to comply with they being accredited or not there and use this third-party verification company. And I'll definitely recommend them for open LLC here, so they pay taxes as a U.S. person, or this is our one.
That's the thing. Yeah, it's like pick your poison. So I mean, if you don't need them to come in under Reg S, let's just say because you're already doing all the docs for the Reg D, right? 506B, 506C. The easiest thing would just to be send them the PPM, send them the exact same documents, and not worry about Reg S. And so if you're doing that, then it's better for you that they set up a US LLC, get an EIN, because then all you need to do is send them the distribution to their US bank account and issue them a K1. So that would be the easiest. But if you're doing a, a 506C, and so you can't take any non-accrediteds, and you've got a couple of non-accrediteds over there, then maybe we look at the Reg S. But in that case, they would not be able to, open a US bank account, and we'd have to do the withholding.
Yeah, because you said the accredited rule is from US citizens in
It's from
person.
the US citizen, yeah. Again, I don't know what the rules are. Like, yeah, good point. I mean, I
Like million, 10 million. So like 1 million, like it's like sophisticated, and 10 million is like accredited. It's like something like this, but invested.
Yeah, and that's the issue that so for you, it's much more pronounced that you have to worry about the Brazilian securities laws, because there's a good chance that you're physically in sounds like you visit back home, just like I visit. Well, I haven't been there in a while, but I visit Chile. I used to visit Chile. But you go to Brazil once a year, twice a year, you meet with friends, and then you have business meetings physically in Brazil. I'm pretty sure the Brazilian government's going to care whether you're violating, because you're technically raising money now in Brazil. US doesn't care, but your Brazilian securities authorities, I'm sure, will. So that's a good point. So you're going to have to make sure that they're complying with the Brazilian accredited investor definition. And then hopefully we can bring them in under Reg S, and so not worry about the US. But that's your pick your poison. If you want one, you can't get the other, and vice versa.
All right, thank you. That's
Yeah,
great.
of course. Thank you. Good seeing you.
Thanks, Sindel. Taylor, I see you had a couple questions in the chat, but you jumped up here, so go ahead and unmute yourself and you can ask yours.
Okay, thank you. Yeah, so we did the thing with our first investor. They wired us the money. We made sure that they actually signed the safe, which they hadn't, saying they're an accredited investor and all that kind of thing. And then found out after the fact about these Blue Sky law filings. So my question is, if we're past that 15-day time period, can we just void the previous securities document, the previous safe, sign a new one, make the filing, and everything will be good? Or is the only way to rectify that through a rescission offer?
Did you say safe? Is that what you're?
Yeah.
That's funny. I think Zach's in here too. I had a question from Zach. I was going to read it in terms of safe. So,
Zach's my partner.
Oh, Zach's your partner. I was like, okay, wait a minute. So, okay. So, and actually I had to look up the name of it, but I keep forgetting. So safe is a simple agreement for future. It's kind of like a convertible note, except it's for equity, right? So it's a contract that you're giving them the right to, depending on some triggering event, you'll give them equity in the future, but you're not actually giving them equity right now. That's a security, just like anything else. So even though it's a fancy name and it's a fancy structure, at the end of the day, it's a security. So the important thing to remember when you're talking about the sale of the security and whether you did it properly or not, is that the sale of the security happens, or the violation happens, when you actually sell that security. So the date that you sold that, meaning that's up for debate, but the minute they wire you money and then you wire them, whatever documentation that solidifies that transaction, that's when the sale happened. And you either complied with the securities laws or you didn't, right? So once it's out of the bag, there's no way to kind of put it back in the bag. So from a security standpoint, what you can do is you could go back to the investors and basically do a rescission letter, which is like, hey, I mean, you're not going to say it this way, but basically, hey, look, we kind of screwed up and we didn't follow the rules. And so we're now following the rules. So here's a PPM, here's all the legal docs. But if for whatever reason you want to back out, you have the right, we'll refund you your money plus interest. So it's letting them know that, we didn't comply, and per the securities laws, we're offering you the opportunity to get out. Because at that point, if they refuse to get out and say, no, that's fine, I'm going to sign the documents and move forward, it's going to be extremely difficult, even though technically you violated the rules of the Senate, it's going to be extremely difficult for them to recover any damages because they have the opportunity to get out. And the key is just to make sure it's very clear from that rescission letter that they do have that option to get out. Because that's the first thing about just in general the securities laws. Regarding the 15 days, I'll be a little bit less concerned about the 15 days. The Blue Sky laws, the 15 days, it's not a prerequisite for, it doesn't blow your exemption, first of all. So if you did everything, I know you've got two things going on, but assuming you did everything right from the raise, the fact that you blew the 15 days and it was maybe 20 days, or you've just completely forgotten about it, that doesn't blow your exemption. There's a large, I'm not condoning this or encouraging this, but there's a large percentage of syndicators or syndications that don't even file a Form D or the Blue Sky filings. And they just kind of go under the radar. And it's like, are you going to get caught or not?
So the Blue Sky laws and the Form D are two different things?
Yeah, so the Form D is the form that you file with at the federal level with the SEC. So that's required within 15 days of your first sale period. That's a free form. There's no fee. There's no nothing. We have a guy, Mike, who does it for us, just because when I tried to do it when I started my career, I felt like you needed a rocket science degree to figure out how to set up an account and file it with Edgar. But that's free. That's easy. Then each state that you have an investor in, they require you to file a copy of that Form D with that state, along with some other docs and their fee, right? And some states, Florida, $0. Other states are usually $100, $200. Some states like California and Texas, I think there's like $300. And then New York's crazy and they have like $2,200 fee or whatever. But they just want their fee. But it's just an electronic. It's done electronically now. You just send a copy of that Form D to the state, pay your fee, and you're done with it.
So once per state, not once per sale or investor?
One per state, correct. One per state. Yeah, so once you got the first investor in, then we don't have to worry about filing another one in that particular. But anytime you have a new state, that's when you want to make sure you advise your attorney so that they can then, file that with the particular state.
Thank you.
Yeah, of course.
2 jurisdictions that you didn't mention that just don't play. DC. If you're late in DC, just wait and see if you get caught, because like a $10,000 fine. And then Tennessee likes to send nasty letters. We've got our own contact, because a lot of our clients, for whatever reason, raise money in Tennessee, and we've got our own contact in the Tennessee the securities arm.
Yeah, and some of them are just a pain. So it's better to do it. It's really not that hard if you're doing it right, and just your attorney should do it for you and keep track of everything. And that should be the service that your attorney's providing, is that full service. I do, not to pick on anyone, but there was one attorney that wasn't doing it. And I always felt that was interesting. It was almost like going to a hotel room and when you check in, for them asking if you want a bed in your hotel room. Like, yeah, so I don't know how you would do a syndication without doing the Blue Sky laws, just like I don't know how you would go to a hotel room and not have a bed automatically assumed in there. But anyway.
Like Spirit Airlines, you pay extra for a seat.
Let's go. I forgot to mention at the beginning, I do have a hard stop at the bottom of the hour, so I want to make sure that we get as many questions in there before then.
All right, Anton, you are next, sir.
Oh, thanks. Thanks, Mauricio.
Anton, how are you doing, my friend?
Yeah, very good. What about yourself?
I'm doing great. Good to see you.
Yeah, same here. It's less of a question, but more as a comment. You mentioned that when wires come in through major money center banks and all that, then
yes,
you should generally be safe when it comes to KYC and anti-money laundering. I would suggest there, right, that there are 2 standards really when it comes to banks, when it comes to wire transfers that come in. Yes, they'll look at them, they may hold them up, but it's a very different standard for wire transfers compared to when they establish a bank account for someone from abroad. And the responsibility to actually verify that someone is properly vetted and that there is not money laundering going on, even if the wire comes through, it's still the obligation of the recipient, right? And don't ask me how I know. I have been in international activities for a long time. I have been in international banking before I left banking, so I've seen crazy stuff there. And at the end of the day, you really need to know your customer. If you are not 100% sure, I would always recommend, and that's actually what we have done with our own clients, have them establish bank accounts in the US, unless you can be 100% sure that there is no risk of any anti-money laundering or any other type of criminal activity behind that money.
What do you guys, because we probably should have started from the beginning. Anton is obviously, as you mentioned, a former banker and very involved in the financing part of international financing. What steps can you take on the anti-money laundering side? Or are you saying, obviously, if they set up an account, that's not going to be any worry. But if somebody's wiring $5 million from Germany, right? Are there steps that you guys typically recommend taking to make sure that you're acting as a reasonable syndicator, to make sure that, what is my obligation there? What would you be recommending there?
Yes, so there are some companies that provide that service.
Right.
The problem is they are not really taking the legal responsibility. So I wouldn't really trust those companies necessarily. What I would recommend is to have a law firm and or a CPA in the country abroad to verify that entity or that individual or these individuals that money is legal. Usually, if it's a clean person, the lawyer and or the CPA are doing that. It's still a risk, but at least you can prove to the US government if they come after you that you did whatever you potentially could do, right?
That's great. That's awesome, Anton. Thank you for sharing that. Yeah, I mean, our obligation is always to act as a reasonable, prudent syndicator would under the circumstances. So and I have not been mentioning that, but I mean, if you can get a law firm in the country or a CPA, some kind of like almost like a verification letter from them, I mean, that to me, that sounds like you're acting like a reasonable, prudent syndicator. So appreciate that, my friend. Thank you for adding value there. I really appreciate that.
Welcome.
506B.me is in the house.
How's it going? I got a question that's actually a lot for Anton there, which is I was just thinking about validating those credentials and translation. So as far as like translation goes, like do you need like certified copies at some sort of embassy or anything ridiculous like that?
I would not necessarily say that you need it notarized or certified. It's all up to you, right? Because there are no real laws that the US government tells you what you need to do. It's really for your own protection. It's similar when someone says, well, I have certain assets abroad, and they say, show you a bank statement or a profit and loss statement. Ultimately, if you do not believe in it, then you have it validated. If you trust it, then it's okay. If it's a language that is generally not known to the US side, then I definitely would ask for a translation. And in a worst case, I would have it notarized.
Yeah, and I can also add, having done, I just got back there a couple of weeks ago, a business in Mexico. You know, the Mexican, they'll translate it into English, but ultimately from a legal perspective, the original language is going to govern. So even if I don't even think you would necessarily have to get it translated in that country, you get it ultimately translated here. But if there's any dispute as to the quality of the translation, the original language is going to prevail.
Yeah, I was just thinking that also, like in a place like Germany, they'd probably have standard English versions as well. Whereas, like, you know, I'm thinking from experience in Taiwan, where this stuff's in Chinese.
100%, yeah. So yeah, that's a good point. But I mean, I would get it translated for sure, so you can at least. But ultimately, if there's any dispute as a translation, I mean, that's going to end up in, you know, it's like anything else, going to end up in court, and you're going to have to get your expert witness, who's a Taiwanese translation expert. They're going to get their expert, and you're just going to litigate it if it gets that far. Yeah. Thanks, Dan.
Thank you.
Thanks, Dan. Looks like we have one more question. If you do have any questions, go ahead and put them in the chat right now. We've got just a few more minutes, but if Clive did
actually well, I've got one that came in. I didn't realize are there any other questions about the international stuff, or do I actually want to go?
Yeah, Clive had
okay, sorry, go ahead.
Let's see here. Where is he? Clive Davis, are you still on? If not, I can read it for you.
Clive's in the house.
No. All right. So Clive says, Mauricio, I assume permanent residents are treated no differently than US citizens, regardless of where they currently reside. Same with residents with dual citizenship.
Correct. The definition of the defined term is a US person, and that's got a long definition. It includes entities and LLCs or whatever, but a US person would include a US citizen and a US resident. So yes.
Perfect. And we'll send him the recording so he can get your answer.
Yeah.
That was it. So go ahead, whatever you're going to read.
Well, somebody, you know, this was an interesting topic, and I mentioned it in the Facebook group because somebody asked it, and I think you and I talked about it too, Bethany, and that is this issue of being an accredited investor when you're a sponsor of when you're a sponsor. Like, you know, does that make you an accredited investor for everything? You know, how does that fit in? And so if you are just a sponsor in a deal, that doesn't automatically make you an accredited investor for that particular deal. The statute says, or really the accredited investor rule says, that you have to be basically either the manager or an executive officer, in this case of the manager, right? So if you're just and the issue comes up when you have multiple sponsors, but if you have 5 sponsors and only 2 of them are the managers and the other 3 are just members, that's not going to qualify them under the accredited investor status. So if you're doing a 506c, for example, and those sponsors are not accredited, that's going to be problematic for you because, you know, in order for it to be a 506c, everybody has to be accredited. But more importantly is just because let's say you are a manager or, you know, or an executive officer of the management company, so you are an accredited investor, that's only for purposes of your syndication, right? It doesn't mean you're an accredited investor to go invest in somebody else's deal, or more importantly, if you're doing a fund of funds, right, and you're investing into another fund, and in order to be eligible for that, all of the members have to be accredited. You being a sponsor or anything at that, or even a manager of that fund of funds isn't going to help you in terms of being an accredited investor, because it only applies if you're only accredited investor if you are the investor of the issuer, meaning of the syndication. So I want to make that distinction because that has been coming up quite a bit, but the statute specifically says director, it actually says director, executive officer, or general partner of the manager or the general partner. So I don't know if that actually, now that it came out, it can be a little bit confusing, but just be careful there when you're thinking you're an accredited investor when you're not really an executive over at the syndication level.
Right. This one comes up a lot now when we see larger sponsor groups, and particularly when we see students with their mentor co-sponsors who'd like to invest in their own deal, but who are really on the sponsor team just to get experience, who aren't otherwise accredited. You are going to be precluded from investing in your own deal in that regard.
Yeah, you're gonna have to do a 506b in that case.
Yeah.
All right.
All right.
Anybody else? We'll give you a few more minutes here, and otherwise, really appreciate you guys sticking around with us on another live, and really enjoy doing these. But did you put that? We'll send out the recording, but I'll also send out an email about the panel tomorrow with Kathy and Ashley and Maureen. And then stick around for Ken McElroy next week. That'll be a good one. Always good to have Kenny in the house. So we'll see you guys hopefully tomorrow with the panel. See you guys soon.
I got the Facebook group too. I put the link in the chat, so you'll get the recording in the Facebook group. And you'll also be able to see the invitation for tomorrow's live in the Facebook group.
Perfect. And if you haven't joined the Facebook group, I would encourage you to do that. It's in the email I think that I sent out today. But anyway. All right, guys. We'll see you next week.
Thank you.
Bye.
Thank you.